Russo, and I'm the Education Associate for HBMA and your moderator for today's presentation. I'd like to welcome you to today's webinar, The Do's and Don'ts of Employing any Remote Workforce, presented by Jennifer Kirschenbaum. Before we begin, I'd like to address a few housekeeping items. First, today's webinar will be recorded and saved on the HBMA website, which you can access at www.hbma.org, and it will be located on our Education On Demand page. Check out this recording and other great online offerings we have available. Second, I would like to encourage you to submit questions during the presentation. You can do so by selecting the Question tab on your control panel. This is located in the upper right-hand corner of your screen. Simply type a question, hit send. As time permits, we will answer questions from the audience at the end of the program. Or you'll also be able to reach out to Jennifer. You can see her contact information on the screen right now. And now I'd like to introduce you to today's speaker. Jennifer Kirschenbaum manages Kirschenbaum & Kirschenbaum's PC Healthcare Department and devotes her practice towards representing healthcare professionals in billing, coding, and credentialing professionals in all aspects of operation, including contract creation, regulatory compliance, licensure matters, audit defense, and as well as serving in general counsel capacity. And with that, I'd like to turn it over for Jennifer. Jennifer, welcome to today's webinar.
Thank you, Nicole. It's my pleasure to be here today working with HBMA. For those of you I've not had the pleasure of meeting yet, I have done several seminars for HBMA in person at their conferences and hope to see you or meet you at some time in the near future. So today's topic that I've been asked to speak about has actually had a lot of activity on, and I know is one that's near and dear to the majority of our listeners' hearts, remote workforce. I know many of us are employing employees remotely. So I received actually a number of questions, a lot of questions actually, prior to today's webinar, and I've tried to incorporate answers to many of them in the materials that we'll go through. So hopefully those of you who asked are listening and will get your answers today, and if not, again, the webinar will be available on the HBMA website. Before I get started, sorry, let me just get this working. I do like to just give a little bit of background on our firm, so that way you know what kind of questions you can ask me, and I'll be able to field, or someone in my firm will be able to field. We have 20 attorneys. We're located in New York, and we do work nationwide, particularly for contract work especially. And we have two areas of expertise in particular at the firm. Obviously, we have a general practice across the board and can handle a lot of general questions, but we do specialize in the security and healthcare industry, which makes for a very interesting mix for our relationship with HBMA, as both security and healthcare are implicated in medical billing and credentialing and coding companies. So it's a very nice mixture and allows us to answer a lot of questions that come up for those of you who are listening. Other areas in the firm, or I guess kind of practice areas that blend into the areas of expertise that we do focus on, is litigation, transactional work, any types of contracts with employees or partnership or mergers, acquisitions, bankruptcy, real estate matters, matrimonial, and collections. Now, the litigation portion of our practice, we do take cases on in New York and New Jersey and also Connecticut, but if you're in other areas of the country, we are normally brought on in a consulting capacity, which does happen, unfortunately, on a regular basis if we're needed somewhere else. So our healthcare practice, we represent billing companies, coding companies, credentialing, and also we represent about close to 900 or 1,000 medical practices. I can say internationally now because we have actually one client in Mexico, so kind of all over the place, spread out. We assist these practices in pretty much everything, soup to nuts, employment issues, licensure issues, audit defense work, any type of litigation that comes up between partners, and also practice collections, which does normally bring in, of course, their billing companies. We do have a number of compliant forms available, which we'll talk about later very briefly. And for HBMA members, because of our special relationship with the group, we do offer free consultations and reduced fees. So do not ever feel worried about sending me a question, which you can do to my email at any time. That's probably the easiest way to reach me, or by phone. I'm happy to field them and answer whatever I can. So we're happy to do that for HBMA members. Okay. Our agenda today, which is as requested and very specific, is about the do's and don'ts of your remote workforce. We're going to talk about hiring, proper classification, how to pay, unemployment benefits, sick days and holidays, and then I think the biggest topic, which we'll see how much time we have for it, managing your remote workers through company policy, and then how to terminate a remote worker, which a lot of these topics, as I was going through and preparing for this webinar today, there are significant deviations on how you would approach a remote worker. But at the end of the day, a lot of the policies on how you approach a remote worker are going to be very similar to how you approach someone who is reporting to your company on a day-to-day basis. At the end of the day, documentation is going to be incredibly important. So just because someone is out of sight and possibly out of mind does not mean that we can be lax on our requirements from an HR functionality. And I think that that's one thing you're going to hear today. That's me stating it explicitly and directly at the beginning of our talk, but I think that that's going to be a current theme that you're going to hear one way or another as we go from topic to topic. And I do know that for many of us this is a lunch break, so I will try to keep the comments to below the hour marks. That way we do hopefully have some time for some questions. So to get started, to hiring a remote worker, it's difficult to give very specific practical information that you're actually going to follow because a remote worker is remote for a reason. You're hiring them, I'm assuming, either because of the pay rate that you're looking to pay, maybe not accessible in the marketplace that you're looking at, or maybe it's someone with a particular expertise that is just not convenient or accessible, or maybe you just feel that you don't need to expand to have more space for this person to come in. But regardless, this person is obviously far enough away that they're not going to be checking in regularly to your location. Or in the alternative, you may be tuned into this call where you just have one or two people that want to work from home one day a week. What we're going to talk about today is going to be applicable to either situation, someone who's working entirely from home or someone who's working from home part-time. Or, by the way, if you're tuning in and you don't have any remote workers, but you let people sign in from home, then some of the security issues that we're going to talk about today and the practical issues of having people work from home, period, is going to apply to these individuals as well. So how do we deal with the hiring of a worker in general, which is what this slide actually addresses? And in particular, I want to make some specific comments to someone who's working entirely from home. But anytime you are bringing someone in and having them join your team, which many of us look at our teams as families. We spend more time at work than we do at home. So you really want to make sure that you have a proper vetting process, that you're not cavalier with your hiring practices. Now, of course, an interviewee is going to come in, put their best foot forward, and it really does take typically anywhere between 3 to 6 months to really see if someone's going to work out. But you really could have a better screening process where you should know immediately if someone is definitely not going to work out. And that may not be something that you can learn on a 15-minute phone call interview, which is what might happen if you're dealing in that situation with a remote worker. I would recommend, if we're in the scenario where we're possibly looking to hire someone who is completely remote, not coming in at all, still bring them in for an in-person interview. Even if you're footing the bill for them to come in, or you're not required to foot the bill for them to come in. They're not an employee of yours, and this is not working time. So you could ask them to come in and make them pay their own way if you're comfortable doing that, and have them come in for an in-person interview. I always recommend a background check. It is not necessarily required for your industry. However, the individuals who are coming in are going to have access to very, very sensitive information, whether that's payment information or protected health information under HIPAA. So you want to make sure that the people that you're hiring do not have a sordid past or one that would raise red flags. Because if it is the case that they do, you will be responsible for bringing them on board and the exposure that they're bringing to you, unless, of course, you're contracting away that type of liability. Still, you may have potential exposure. So you want to make sure you do a background check. plenty of jurisdictions allow drug testing, assuming that you have consent. You may want to look into that as well. But the background check to me is a much bigger thing, and you're going to need consent from the employee to get it. You want to make sure, again, as I said, face-to-face meetings is definitely recommended. So hiring, pretty general comments, pretty standard on what you would do for any other type of employee who's coming in. But I do want to stress the face-to-face meeting. I think that it's terribly important if you're bringing someone onto your team, especially someone who's going to have access to sensitive information in the company. You really do want to know who you're working with. So documenting hiring, and I'm sorry that this is very verbose, but I decided to take it straight out of the Federal Fair Labor Standards Act, which we'll be talking about the beginning part of today's webinar in a good bit of detail. But you are required, and this is for any employee, okay? We're going to deal with independent contractors separately to an extent as we go through today. We're going to talk about some differences. But record-keeping requirements for any person who comes on board, and I would recommend that you have this on file as well for your independent contractors. You want to make sure that you open a file for each individual who you have on at the company. You should be doing this already, where you have the full name, their address, their zip code, their gender, occupation, the time and day of the week that they started working for you, how many hours you anticipate having them. If it's going to be a more flexible independent contractor, obviously this is going to be more vague in your documentation. Their regularly hourly pay, time earnings, overtime earned per work week has to be tracked, additions and deductions from their wages, total wages and date of payment, and the pay period covered by payment. A lot of issues that I see or get calls on from clients is related to wage hour claims. And the issues that arise from that type of exposure can be severe, but easily mitigated if you have a proper timekeeping system in place. And for a lot of companies, I'm actually, I endorse the outsourcing. I know that there may not be the best, but there's some very large operations out there. ADP, Time Checks, I think is one of them. And I think that it's important to, for one thing, if you're outsourcing this type of functionality, you have another person to point a finger at if you're not getting the reports that you're supposed to have on file, and they may actually have insurance to protect you in case there is some sort of exposure. If you are doing this stuff in-house, it is not enough to keep this on a piece of paper that you could lose and you're not tracking properly. This is an area of major, major audit and exposure, and we'll talk about what that means as far as ramifications for your company, and it's a very easy area for you to actually cross your T's and dot your I's. So you want to make sure that for your employees, you're properly documenting their pay. And we'll talk about what that should be today also. I'm going to make sure to cover that for you. So as you bring on a new hire, I do recommend that there's something in writing tracking from you to the employee what the deal is. That does not have to be a full-blown contract. I'm not trying to advocate for that. If you are bringing on someone who's a higher up in your company that you're looking to restrict possibly from soliciting or from operating in a certain range, then yes, you will need a contract with that person, and you should have certain covenants in there. Otherwise, a simple email could suffice. Welcome to the company. We're so pleased to have you. Here's your agreed upon deal, and then you give the terms, straightforward. When are they starting? What are their hours? What's their pay? And this way you have documented exactly what it is the deal is, and it can't be challenged. Acceptance of policies we're going to talk about a little bit later, but you should not have an employee start or have access to your client database or to any protected health information, period, prior to accepting the policies of your company, which should be on file and should include how you treat protected health information. That is incredibly important, and we will spend some more time on it a little bit later. A major question for employers is how do I classify my workforce? And for our purposes today specifically, how do I classify my remote workforce? Are they an employee or are they an independent contractor? There are a number of different standards established to determine whether or not a person is an employee or an independent contractor. It is not based on whether or not you want to withhold taxes on the person's behalf. That is the last thing that is taken into account when considering whether or not someone is actually an employee versus an independent contractor. So when we look at the U.S. Department of Labor, they give this definition, and here is the link that I pulled this from. But they say that independent contractors, by definition, are self-employed because they are not employees. They are not covered by employment, labor, or related tax laws. And employers may be tempted to reclassify in order to avoid taxes, which they're acknowledging. I'm telling you, you shouldn't do. And they do acknowledge that statutes usually fail to clearly define the term employee, and no single standard exists to distinguish, which is unfortunate. But I'm going to give you some factors to think about whether or not we've misclassified in our own organizations. The Department of Labor continues, which is relevant to our purposes today, and states that the mere fact that a worker works from home or off-site is not indicative of independent contractor status. The question here that they're raising is, does the employer exercise substantial control over the working relationship, even if it exercises less day-to-day control over the employee's work at the remote work site? So just because you're not there looking over the person's shoulder, if they're authorized to take work home and finish some things up at night, at the end of the day, are you dictating how your clients are being serviced? Is it your policies and procedures that are being followed? Are they your clients? Is it your system that this person is using to do their work? If these questions are being answered in the affirmative, that yes, it's my clients and they're doing it my way, it's my company, I built it, this is how I want things done, just because they're working from home is not a factor. I was going to say it's not a definitive factor, but it's really not even a factor as to whether or not this person is an independent contractor or not. Now, there's, of course, benefits why someone coming in would want to be hired as an independent contractor. They may have their own tax reasons why they want, a lump sum going into their coffer. That's what's important to you is that you follow the laws and that you are adhering to your tax responsibilities, so that way you do not have threat of audit or sanctions or penalties as a result of a misclassification on your end. So we want to be really careful about that. The IRS also has a factor test, which is usually deferred to. There's been recent case law to kind of take it out of the IRS realm that shows other factors that are being considered, which is really just, how much control does the employer have. But the IRS standard, I think, is a really good fallback and one that's important to note on when you're classifying employees versus independent contractors. And they state that the general rule is that an individual is an independent contractor if the payer has the right to control or direct only the result of the work and not what will be done and how it will be done. So if the process itself that's utilized, so let's say we're a billing company and we are hiring a coding expert. We don't have a coding expert currently. This person is completely new to our organization, and they want to be hired on a 1099 independent contractor basis. This person has been trained. This person is certified. This person is going to be working from home, and we're going to be giving them entire projects, lump projects, where we have no idea how they're going to be going through it. We don't know which E&M standards they're going to be using. We're not telling them how to apply Medicare local coverage determinations. This person is completely operating solo, and we just want to make sure that the product gets done, that there's a report given back to the client who's paid us for this coder's work. Is that person independent? I would argue, and don't take this to the bank, but I would argue that absolutely that person is an independent contractor, and we can hire that person on a piecemeal basis, a per project basis. We can pay them completely differently how we would pay an employee. We do not have to maintain withholding taxes, and the reason is because we are not asserting any control over that individual on the process and how they're doing their work. Now, the IRS offers additional guidance. They say you are not an independent contractor if you perform services that can be controlled by the employer. This applies even if you were given freedom of action. What matters is that the employer has a legal right to control the details of how the services are performed. So you can see our example with a coding expert. If the employer says, I don't know anything about the details, I don't do coding, I don't want to do coding, I hired you to do the coding, we're going to have, we're probably going to be able to meet the factor test by the IRS, which is here. They have these other 3 categories that they give as distinction on determining whether or not we have an employee or an independent contractor. And it's very simple. They identify behavioral, financial, and the types of relationships. So does the company have control or right to control what the worker does? Are the business aspects of the worker's job controlled by the payer? Again, we talked about this. And types of relationships. This is definitely not going to be definitive, but are there written contracts in place or any employee-type benefits extended? So again, just because you offer someone health insurance or not health insurance doesn't get to the control element. And so it's going to be a multiple factor test, and really these issues are dealt with on a case-by-case basis. So if you are audited for misclassification, it's going to very much depend on what is going to be considered as important and weighed in your favor or not in your favor. So as I put here, and this is also straight from the IRS website, there's no magic or set number of factors that makes the worker an employee or an independent contractor, and no one factor stands alone. So if you do have questions on whether or not you've classified correctly, you do want to make sure that you speak with an attorney who specializes in this. Our firm certainly can help. Or you may want to run it by your accountant. If you don't feel very confident in your accountant's determination, you can always feel free to give us a call. We do have on staff of counsel to our firm is Judge Ruth Kraft, who is a retired labor law judge, and she has many definitive opinions on this subject and would be happy to speak with you at any time on this, as I would as well. Okay, so what are the consequences of treating an employee as an independent contractor? If you wrongly classify an employee and you have no reasonable basis to do so, your company, you personally, will be held liable for employment taxes for that worker, and that can go all the way back. So that means that you've already paid the worker, okay? You've misclassified, and now you have to pay the back taxes. And good luck recovering that money from the worker, okay? It's going to be very difficult to do. You're not going to be able to do it most likely. So we don't want to misclassify from the first case. Okay, let's talk about how we pay remote workers. And again, this applies to any workers, but remote workers as well. We've established that a number of them are going to be definitely classified as employees if you're hiring them to continue your main business purpose, and you're going to have control over the process and how they do their job. They're going to be employees. So the Fair Labor Standards Act is going to apply to the majority of us on the phone. There's very few who are going to be exempt because most of us are doing interstate commerce. We have some customers that are not in the state that we originated in. And also we are going to have not less than $500,000 in annual volume of business, hopefully, knock on wood. So if you are covered, which the federal government acknowledges that the majority, over 130 million workers in full-time, part-time, and private and public sectors are governed by the Fair Labor Standards Act, this is what we have to adhere to. There is a minimum wage requirement, as we're all aware. Now, if you're trying to duck out of minimum wage by doing piecemeal payment per project, if you qualify under the Fair Labor Standards Act and you have an employee who, again, is under the factor test, you will be required to adhere to the minimum wage. And unless it's you qualify for an exception, which would be, a seasonal worker or whatnot, which you're not going to likely do, you do have to pay minimum wage. So federal minimum wage is $7.25. I know many of you are thinking, Jennifer, that's not right. My minimum wage is way higher than that. We're going to get to it. States have their own requirements for minimum wage. So that's next. Overtime, you're required to pay time and a half, which is anything over 40 hours a week. Now, the biggest issue that we have with remote workers is how do we get them to document their time correctly? This is my biggest problem, Jennifer. This is why I signed on to this call. This is the only question that I care about. I received this question prior to. how do I handle this? I don't know how to make sure that they're not lying to me and that I'm not overpaying them. Well, I'll tell you this. You have to put procedures in place to make sure that you are properly documenting and that they're properly documenting the time that they're expending for your work. So how do we do that? Well, before they start in your policies and procedures, you're going to have policies set forth that state that they have to, this is their work schedule. They're not supposed to be working outside of these hours or devoting this many hours per day without your prior approval. And most certainly that they are not authorized to work over 40 hours a week unless they receive prior written approval and they can provide substantiation as to why they're requesting to do so. I would absolutely recommend that you put that into your policies. It has to be in there, because if you just basically say to them, just put your timesheet together, send it over to me at the end of the week, and then they end up sending you over 60 hours, well, guess what? You're required to pay them. So you have to set these policies in place prior to giving employees free rein. And honestly, that's a lot easier to do if you have them physically in front of you and they're clocking in and clocking out, which I do recommend that we do have time clocks in our offices. Very, very difficult to do when it's a remote worker because, of course, we're not there to police them and make sure they actually do the work that they're saying that they are required to do. So that's where we are with federal minimum wage. State minimum wage requirements, and I pulled it straight from the Department of Labor. Okay, here is our reference link if anyone wants it. But these are the states that do have their own. If your state is not on here, which you can, go double check me, but these are the states that are on here. If your state's not on here, then again, the federal minimum wage is going to be what comes into place. So at New York, we're at $8. Florida, we have $7.93. For those of us out other places, this is what you've got to work with, and we will most certainly be available to answer any questions if anyone has any issues with this. Okay. So I'm going to move away from minimum wage now because time, as it does, is creeping up on us. Unemployment benefits. This is a question that I was asked specifically. Jennifer, how do I deal with unemployment benefits if my company is located in Arizona, but I've identified billing people in North Carolina that I want to hire to work remotely for me? In particular, how do I deal with it? Well, unemployment benefits is federally mandated, and it's state-run, which we may know that. So each state is going to administer their own unemployment insurance program with the guidelines established by federal law. Now, that being said, not every state runs the same program. You are required to pay in for eligible workers for each state that they are located in. It is governed by the state where the employee is located, not where you are located. So you are going to have to contact North Carolina, and you're going to have to qualify to do business in North Carolina likely, and you are going to have to pay in to the unemployment fund in North Carolina for these employees that you hire. Now, this is not a talk on specifically how to get that done in North Carolina, so I'm not going to go into it in much more detail, but your eligible workers are required to have this as a benefit to them if they meet the eligibility requirements under the state law for unemployment insurance. So you have to adhere to this. If you don't, you're going to have massive exposure. So if you do reach into another state and you hire somebody else, you're going to have to look into the state requirements. I recommend you work with local counsel if you feel necessary, or if you have an experienced HR person who you trust, you make sure that you cover your bases with the state, and you look into absolutely unemployment benefits on how you're going to have to pay them in. Now, just so you're aware, 3 states do require minimal employee contributions, and those states are Alaska, New Jersey, and Pennsylvania. So for more information on unemployment benefits, here's a link. You can absolutely feel free to do your own investigation, but you will have to pay unemployment benefits towards the state for any state that you're reaching into, not already paying. Now, what happens if we say, you know what, Jennifer, this is a lot of administrative mumbo jumbo. I think this stuff's really boring. I don't really want to adhere to it. I'm just going to pay people to do stuff for me, and that's the end of it. And I'm not going to file for any of this stuff. And I'm going to pay them what I think is fair also, by piecemeal, by project. I'm not going to adhere to the minimum wage stuff you just talked about. Okay, no problem. Good luck. Your employees can file a complaint or a private lawsuit against you if they'd like, if they feel that you're not being compliant. And unfortunately, this is a growing area similar to personal injury. We have a lot of attorneys on the other side that are willing to take these cases on, or just troubled employees that don't necessarily think they have anywhere else to go, or, you know, tough job market, they can't find anywhere else to go, and they're looking for money back as, you know, whatever they can get. They're typically entitled, and this is under federal standard, to back pay if it's found that you did do something wrong. And if you did something really wrong, they could get up to 3 years of back pay, and they could get back liquidated damages, which is a scary, scary phrase, because it just means that you could just be punished, and there could be a lot of money that's due and owing to these individuals based on your conduct, which is pretty scary. So I'm not trying to use any fear tactics, but these are very simple administrative processes that you want to make sure you have in place prior to you bringing these individuals on board, and really just running a compliant company. So health insurance and taxes, another question that I was specifically asked about. How do I deal with health insurance and taxes for my employees specifically, and then also if there's remote workers? If I have people who are out of state, how do I deal with it? Well, the health insurance is going to be a tough one because a lot of times it's state specific, and insurers are only working in one state. If you're working in, you know, with a large carrier that's in multiple states, you're going to have to call them and notify them that, hey, I have a worker who's, you know, living in Pennsylvania, even though we're a Massachusetts company, and I want to know, Blue Cross, you know, do you have a different plan? The answer is likely going to be yes, and it's going to also likely be that you're going to have to make some adjustments. So hopefully you have a broker that you're working with that gets paid when you buy the policy and not every time you call, and you can have that person look into what your health insurance options are going to be. Same thing with your taxes. When you have someone who's living in a different state and you're doing withholding taxes, this is something that you're taking on. If this is actually going to be an employee who's coming on, you have to have proper withholdings. So you're going to have to notify your accountant as well as your insurance broker of your intention to expand your company. Now, if you have no intention of offering benefits to an individual that you're hiring somewhere else, you're still going to have the tax issue. So either way, you're going to have to make some inquiries before you make that hire and make sure that you have your ducks in a row prior to that offer going out, and you know if this could have potentially, on the health insurance side, cost your company tremendously more to give a comprehensive offer to this individual. So just be really careful there, and you want to make sure that you have the information in front of you prior to you looking into hiring someone that's specifically out of state. Now, of course, hiring someone remotely doesn't necessarily mean they're going to be out of state. It might just mean that you're not interested in them working full-time out of your operational office, and that's fine. But if you are interested in hiring someone full-time who does live out of state and you are looking to extend benefits to them, then by all means, please perform your due diligence before you extend that offer. Sick days and holidays for remote workforce. Well, we've covered hourly employees up until now, basically. You know, we're not dealing with salaried employees. So some local jurisdictions, for instance, New York has just implemented a 5-day sick-day policy required. Some other local jurisdictions do have mandated sick time. For private companies, there is no required holiday period. You are not required to give holidays. It's just your company policy if you do. If you're closed Christmas, you're closed New Year's, you're closed July 4th, that's just because you've been nice and you've allowed your employees not to work on those days. But no one says that you have to close on those days. That's entirely up to you. Sick days also is governed by company policy for the most part, unless there's a superseding law, which you'd have to check locally if there is. So it's a question on whether or not you want to extend it. Now, for your remote workforce, if you're not classifying them as your full-time in-office staff, you're still going to run into trouble, I think, if you're giving paid sick days to to your workforce. And if you're thinking about not extending paid sick days to your remote workforce, I would definitely encourage you to contact our office and make sure that you're working with an attorney on your policies and procedures to make sure that you have on file defensible standards that we could explain why this person does not meet this group of employees and does not have to be given the same as the others, because that's really the test in employment law, is do you have other people being treated one way and someone treated disparately? And if that's the case, then why is there the disconnect? And you have to be able to show it through your company policy why there's a disconnect. So that brings us to the meat and potatoes of our conversation, which I'm sorry is so one-sided, but that's how these webinars work. I talk, and hopefully you listen and are interested enough to hang on through the hour. But this is where I think, you know, the real issues come. So managing a remote workforce. Well, we've already kind of talked about or dipped into company policy a little bit, and what I think, you know, is really important for you to have on hand, but we didn't get very specific. So let's get specific. And this goes for just what you should have in your company, period, not necessarily just because you have remote workers, but some of the stuff is going to be specific for remote workers, which we'll get to. The offer letter and contract we discussed, we want our people to understand, so that way they have legitimate expectation on what we expect from them and what they can expect from us. And the most simplistic terms of that are, what are we going to pay you, when do we expect you to work, and what services do we expect you to provide? And that would be the offer letter. And again, if you wanted a contract, if you were looking to restrict them in any way, or you had some additional things you wanted in there, or they're taking on additional responsibility, then you could look to a contract. And by the way, if we're talking about someone who's coming in at an executive level, or someone who is a supervisor or manager, that person could potentially be a salaried employee and an exempt worker under the wage hour laws. But we would have to really show that that person qualifies as exempt, and you'd want to make sure that you run that by a professional if you could before classifying them as such, and that person probably would need a contract. Your employee handbook. This document is supposed to be your Bible. It is a living and breathing testament to what you believe is appropriate conduct at your place of business. And it is something that when I put it together for a client, I try to encourage them to not throw it into a drawer and never look at again. Your employee handbook should be given to any new employee who's taken on. It should be reviewed on an annual basis by you. It should be trained upon by your HR manager on a regular basis, and it should be referenced anytime we're writing someone up for wrongdoing. So what should be in there? Your employee handbook should be your code of conduct that you expect from your employees on a day-to-day basis. It'll also include what your policy is on benefits, vacation, sick time, jury duty, bereavement leave, possibly maternity leave if you're going to be addressing that. It's also going to talk about your confidentiality policy in the office. We're going to get to HIPAA and security policy separate, but you'll deal with confidentiality in there. You may want to put in a non-solicit that if they go to work for another company, that they're not authorized as an employee to reach out to any current clients. And we would be able to utilize that, assuming they signed off on it, as if it were a contract, and we'd be able to enforce that against the employee. So there's a whole slew of things in the employee handbook that are really extremely helpful in allowing us to police the employees, and it should be referenced again anytime you write someone up for misconduct. Your compliance plan. This document is required if you are billing for Medicaid services, straight or non-straight Medicaid services, which would be HMO Medicaid services or the like, in excess of $500,000 or more on behalf of your clients. OIG, the Office of Inspector General, gave us an idea of what they're looking for this mandated compliance plan to be in place, and we recommend that if you are operating in that Medicaid sphere, that you do look into adopting it. It basically just talks about red flags that you're utilizing and how you try to operate properly, and it also, I think, helps frame what you should be responsible for as a billing company versus what the medical practice should be responsible for as the medical provider, and that they're actually creating the information and you're merely a conduit for transmission, which is very important for you to maintain in your relationship to mitigate any potential liability that could be implicated to you for any inappropriate billing that's being done by the practices. HIPAA and security policies. Now, all of us hopefully know that we qualify as business associates and that we are not the actual covered entities under the HIPAA law. That meaning that the covered entities being the hospitals, the physician practices, and other providers, and the business associates being the ones that are tangentially involved with protected health information for us to get our work done. So all of us likely qualify as a business associate. The HIPAA laws extend to the business associates through affiliation. The HIPAA laws are drafted and written to cover the covered entities, but by association we get dragged in. And through our business associates agreements, many of us actually accept responsibility for breaches and other issues with protected health information. So since that's the case already, I do recommend that each of us have on file HIPAA policies that show that we are compliant with HIPAA, or we're doing our best to comply with HIPAA, that we have our business associate contracts in place, and also our security policies, which shows what we are doing as a company to secure the electronic protected health information that we have flowing through our company. It doesn't necessarily have to be electronic. I just assume that everyone on the call is using electronic at this point in time. And the security policies that we have in place would talk about encryption and security measures that we have on place at our company level. Now, I know I'm talking about the company level now, and this is a remote workers talk, so I will get back to it on what we're going to do with them. Training and education, we want to make sure that we know exactly who should be reporting where, and the documentation requirements that we have in place for education and training. We want to make sure we have that on file. So managing remote workers specifically. So, and this is anyone who's working from home. This is you included, okay, whoever you are. If you're the owner or you're the manager or you're the HR person, if you're logging in remotely or you have access to your system from home, this is very, very important for you and everyone in your organization and for your remote workers to make sure we enforce. The proper policies that we want in place when addressing remote workers for equipment and access management are specific. We want to maintain an active equipment issuance list. So if we have people coming in and working from home, we want to know, how are they able to get access to our information, which includes confidential protected health information? Are they going to be issued their own laptop? Are we giving them any storage devices? If so, we want our employees signing in and signing out when they receive and when they return. We also want them to sign over policies that explain that they are the only ones who will have access to this equipment. They will notify you immediately if it was lost, stolen, or if there's any unauthorized access. They are required to maintain password protection on that system at all times. This is very, very important. And we need to make sure that we know exactly how they are able to access in and out. The password protection, we want to make sure that at all times we know the employee's password or we're able to get onto their system if need be. And again, I talked about access, but physical access has to be completely in the control of the remote worker, that they're taking 100% responsibility. So what happens if we have a remote worker we issue a laptop to, and this person is a real night owl, so during the day they let their 7th grader take the laptop we issued to school. And we may have completely remote system where they're logging in, they're using LogMeIn or some other functionality, but this person also likes to download charts or other types of spreadsheets or whatnot with patient information onto the computer, and then the kid loses the computer when they're at school. Well, this is a definite scenario that could potentially happen, and it's one that this is how we handle. It is your responsibility as the employer to have in place a contract. It may not look like a contract. It could be one page that explains to the employee that once they take this equipment from you, or maybe it's not equipment, maybe it's just access, that once they have access to the system and if they're going to be doing any work from home at all, the employee agrees to take on the responsibility for any exposure that may result. And I'm going to explain to you exactly why that is so important nowadays. Actually, before I do that, well, maybe I'll do that first, and I'll come back to this slide. These are the two examples that I pulled that just happen to be available. They are for covered entities and not business associates, but we can talk about how this translates to business associates real easy. We don't have a business associate who's been slammed by the Office for Civil Rights yet for anything stolen, but here's a laptop stolen from Hospice of Northern Idaho. They had to pay the federal government $50,000 for failure to conduct an accurate and thorough analysis of the risk to confidentiality. And a second example that happened fairly recently, these are both within the last year, a dermatology practice had to pay $150,000 for losing a thumb drive that had protected health information on it. Now, why do they both have to pay? Did they have to pay because they lost the laptop and the thumb drive? No. They actually had to pay because they didn't properly report that these things were no longer under their control and possession. And they didn't notify the patients, which they were required to do under the HIPAA breach notification rule. So it's not that they lost this stuff, it's that they didn't have proper protocol in place. So how could this translate to you as the business associate and not the covered entity? Well, it's real simple. With your clients, you are required to have a business associate agreement in place. And if you do not, or you do not have an updated one, because the rules for business associate agreements changed in the last year or so with contract requirements. If you don't have one in place, then you need to get them immediately, okay? And if you do have them in place, then what you want to make sure that you also have in there is what's called an indemnification provision. And what an indemnification provision is, which is not in the free version that's available in the Office for Civil Rights version of BAAs. I'll go back to our BAA slide now. You are allowed to shift your risk through contract. So indemnification allows you to do that. It says that you, covered entity, agree that if it's your fault that there's a breach, you're going to take responsibility for any money that's owed. Now, on the flip side, a lot of your covered entities are going to ask you to take the same kind of responsibility. If it's your employee, Sue, who loses a laptop with my patient information on it, then guess what? You're going to be responsible for the expense. We have not seen a fine yet related to that scenario, but I could very, very easily see that happening. And it's a real reality that we have to prepare for. So I think we've kind of covered that. If anyone has any questions on this type of exposure and business associate agreements with their clients, I'm happy to address. But going back to whether or not you need a BAA with a remote worker, your workers, if they are employees, you are not required to have a business associate agreement. And this question was asked to me prior to this seminar by email, and the answer is very simple. You are not required to have a BAA with an employee. You are required to have a BAA if you have an independent contractor. And again, we'll go back to the certified coder example. This is an individual who is in complete control of the process on how they do their work, and they've been correctly classified as an independent contractor. This individual, absolutely, you should have a BAA with. This is someone who is working for themselves, who is not integrated into your company the way that an employee would be. The employee doesn't need a BAA, well, because under statute, employees don't need a BAA, but also because the employee is presumably signing off on your internal policies and procedures which govern HIPAA information and how HIPAA information is going to be stored and maintained. And this individual, again, is going to be signing on to these other policies and procedures where if they're working remotely in any capacity, we have shifted, hopefully, the burden of and responsibility of maintaining access appropriately to that employee. So what I want to see, and this is maybe why some of you are on this call, period, is I want to see between your employees anyone who has any access from home at all. They should be signing off on that document, which we talked about earlier, that basically says, I, Jennifer, take responsibility for any and all unauthorized use or access to the company equipment and materials and confidential information and HIPAA data and blah, 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 et cetera, et cetera. And I agree that I personally will indemnify and take financial responsibility for any exposure that I create for my misuse or mismanagement of company property and access. So that is what we need. And for those of you who stayed on this long for the call, that's probably what you were waiting for, but that's what you need. And you need to work with an attorney. Our office is happy to help to get that drafted properly to make sure you're protected. So what are we doing with managing remote workers for your protection? We're designating individuals to do certain projects. We're delegating the actual assignment, and we are going to shift the liability by contract with the employee. And the example, again, is an employee working from home with your equipment. The employee signs off for the equipment and signs an agreement to take responsibility for proper use and access. We want written confirmation the equipment will be used by the employee exclusively for the work purposes. Now, the benefit is immeasurable. The upfront cost that you're going to have to put this together and to properly manage, it's going to save you sleepless nights, hopefully. And if this were to come up and there were to be potential exposure, and you know Susie's child does lose the laptop on the way to school, then you're going to know that that you're hopefully covered. Now let's talk about that lost laptop for a second, because I referenced it before very quickly that we need to have a reporting mechanism internally. You want to make sure that you try to foster an environment where your employees are fessing up quickly when they do something wrong. It's a lot easier to brush things under the rug. No one wants to admit to mistakes. But you have to reward transparency within your organization. And it has to be made clear through training that, especially when it comes to protected health information and the patient information from our clients, that if there's any kind of misuse of that data or possible unauthorized disclosure, it needs to be reported immediately. And the reason why is that, again, going back to the examples of the practices that were fined, you will only be held responsible monetarily if you do not properly report the unauthorized access or the loss of the equipment or the loss of the data. You must properly report. So without your employees reporting up the chain how they're supposed to be, you're not going to know, and you're not going to be adhering to your disclosure requirements. You won't be able to address properly. So it's very, very important that we set these standards, you know, at the time when we're delegating authority out to these individuals, and that we make it as a general policy known that reporting is required. So I do have to stress that, and hopefully we've gotten that point across. Quickly, we'll go through terminating a remote worker. It's very similar to terminating an employee who's coming into the practice, the office on a regular basis. Document, document, document. The elements of a proper warning, date, time, and place of infraction, the who, what, when, and where you want to deal with, and how do you deal with documenting. Let's say this is the first infraction, we're not terminating yet. Well, you want to present the employee with what you view them as having done wrong. Maybe it's that they're not devoting the hours that they said that they would if they're working remotely, or maybe they're not seeking pre-approval before they're working overtime, or maybe you're just not happy with their work product. Well, if they're remote, you do want to make sure you still have that conversation with them. Make sure you have more than one person on the phone so you have a witness. And you want to present them with a write-up and ask them to sign off. You can do it by email. That's fine by me. It's a great way to create a record. Just be careful what you send by email, because anything you do send, no matter how hard you try, will never be deleted. So Just be mindful of that as well when you use email for documentation purposes. If you have multiple violations of the same type, you do have to continue to write up, and you want to try to get the employee, again, if you're doing it by email, if they're remote, they're not coming in, just make sure that you have on file that they recognize. Now, let's say we have an employee who's really insubordinate or not responsive at all. If you are communicating with a remote worker by email, please make sure to utilize your read receipt or delivery receipt functionality in your email. Pretty much every email operator that I'm aware of allows you to track when your emails are opened. So if you don't think they're going to be responsive, please make sure to take those steps to make your email read or delivery receipt notification ready. Okay? How and when to fire. An at-will employee, which is a lot of states are at-will, it means that you can fire an employee at any time for any reason, with or without good cause, as long as you're not firing for a discriminatory reason or retaliatory reason. Discriminatory and retaliatory will potentially get you sued and in a lot of trouble. So you can fire an employee for not doing a good job. You can fire an employee for not liking what they wear. You cannot fire an employee because she's a woman over the age of a certain extent and she's not doing the work that you want. That's discriminatory. That's age discrimination. It's gender discrimination. And depending on her background, it may be a couple of other discriminations as well. So just be really careful. And if you do want to fire someone who, I've gotten this phone call before, Jennifer, I have this pregnant employee. I just found out she was pregnant. I was trying to fire her as of yesterday. She told me today she's pregnant. What do I do now? She's in a protected class. Well, you have to be really careful there, and I would make sure that you have, that's why you have to have your documentation in place. If you haven't been properly documenting employees not following the rules in the employee handbook or other policies and procedures that you have set forth, whether they're remote or not, you're going to have a really tough time justifying a firing in general. So, and if you're looking to fight unemployment benefits because you don't want your insurance to go up, you better be sure that you have really good cause, because otherwise you're going to lose that battle as well. So if you find someone stealing, file a police report. Contractual employees are not at will if you've given them a term. So if you gave an offer letter and you said your engagement is for 1 year and we have to give 30 days notice, you will have to give that 30 days notice. At termination, you always want to explain post-separation entitlements, including any severance that they're entitled to, possibly, and any COBRA. I know that a lot of the COBRA laws have been changed with the Affordable Care Act, so you want to check with your insurance broker and see if you're required to still offer COBRA under your plan. If you think you have an employee that is going to cause a problem, you want to make sure that you get a release prior to terminating, and in exchange for the release, you'll have to give consideration, so you may have to give a week or two of severance. Work with an attorney on that. Releases have to be drafted with particularity, especially in the employment realm. EPLI, if you've made it this far, you're going to get a carrot, because this is very important. If you do not have employment practices liability insurance, get it. It's very cheap for the most part. It's an add-on to your general liability policy, usually. Call your broker. It will cover you for any claims that employees make. Well, I shouldn't say any, but most. It covers for legal expenses, which can, of course, be substantial. So EPLI is a cheap insurance that you should get, and I recommend it. Your payroll company often offers it as well. Okay, so do not engage with employee post-termination. What does this mean? If you fire an employee and they contact you by email or they're looking to fight with you, just don't write back. And if you need help with counsel, then please feel free to reach out. So tips for remote workforce. I know we did a lot of general discussion today as well, but really there's policies and procedures that you have to have in place that are specific to people working from home. We know that if you have people working in different states, that we have to make state inquiries on local issues. We know we're responsible for unemployment benefits related to that state where the individual works. We know we're required to minimum wage where that individual works, so we might have to check that as well. We've discussed how we limit ability for an employee to collect overtime, which would be by policy. And I think that is pretty much what I want to talk about. Our resources, of course, our attorneys are our resources. You can feel free to call me or our office for a consultation on any question you may have. Our newsletter, which many of you may already be a part of, we send out twice a week on questions that come in from whoever, and we'd be happy to sign you up. You can email me, or you can just go to our website, and there's a sign-up link on there. Prior articles from our website are available here from our listserv, and other webinars that we have, and also policies and procedures. And I'll just show you, this is our policy and procedures for billing companies specifically. It's for www.billingcontracts.com. Pretty sure that link works. I haven't checked it in a while. But if not, it's just off of our website. And what we talked about today was HIPAA policies and employee handbooks. So if you have your own and you want us to take a look at what you already have, we're not looking for you to spend any additional money more than you have to, but if you do need assistance, then we do offer standardized forms that we can customize, or we're happy to assist you with what you already have on file. So I'm Jennifer Kirschenbaum. Here's my speaker biography again, and here's how you can reach me. And it's my pleasure to turn this back over to Nicole.
Thank you. Appreciate the presentation. Well, we have reached the top of the hour, so if you have any further questions, Jennifer would love for you to reach out to her directly. As you can see, her contact information is there on the screen. Once again, I would like to thank you all for participating today, and I'd also like to thank Jennifer for today's presentation. Please remember to visit hbma.org for a recording of today's presentation in our Education On Demand store. And once again, if you have any additional questions, please feel free to contact us at info@hbma.org, or questions to Jennifer. You can see your email right there. Thank you all again for attending, and have a great afternoon.